I am a lawyer. I have to caveat the beginning of this talk, though, is nothing I say here can be construed as legal advice to any of you. So you can't come back and say, well, you gave me this legal advice and I'm going to sue you because you were wrong. I'm not wrong, but I am not your lawyer, and you're not paying me. So what I say is not legal advice, but I do want to be able to help you and give you an overview of what our rights are as PI patients. I am a PI patient myself, and so I want to give you just an overview of what the basic rights we have in our employment situations, so that you have a general sense of what you can do and cannot do with your employers, as either you have jobs or you're out looking for jobs or you're in between jobs or whatnot. There are questions in the cards if you want to write them down. Depending on what we get, I will ask for questions from the audience. And if you can, I am more than happy to make this a very cooperative session, so that if someone has a question that you have experience with, we can share. I don't have all the experience. I haven't lived all of the scenarios, and maybe you have. So I would be more than happy to defer to some of your experiences. So what are our basic rights? How do I get? The two main laws that protect us as individuals with a disability, and that's essentially what a PI is. It is a disability. The two main laws that will protect us in the employment law arena and with our jobs are the Americans with Disabilities Act and the Family Medical Leave Act, the ADA and FMLA. I'm sure many of you, if not all of you, have heard of those. But what really do they mean? What rights do they give us? What protections do they give us? That's really what we're here to talk about. First, the Americans with Disabilities Act. And as much as I hate it when I go to presentations and people read the slides, this is important. The Americans with Disability Act says specifically, no covered entity, and those are the specific employers, shall discriminate against a qualified individual on the basis of disability in regard to job application, the hiring, advancement, or discharge of employees, your compensation, your training, or your other terms and conditions of employment. Three important things here. One, discriminate. They can't treat someone, discriminate basically means treating someone different than someone else in a similar situation. They can't discriminate against people with a disability. Qualified individuals, it means you have to be able to do the job. You're not going to claim that you were discriminated against by the surgical staff at the hospital. They're not giving you a job as a surgeon if you weren't a surgeon. So you have to, these are for qualified people that like us that can do our jobs, can't be discriminated against because of our PI. And a disability. And disability is defined in the law, and we'll get to that. But PI has been defined as a disability, and so there really isn't much disagreement, legally, whether or not a PI is actually an official disability. And then also one more thing is that this law covers us from soup to nuts, not just after you're employed, but it covers, it prohibits discrimination when you're making an application for a job, when you're being considered for hiring, when you're interviewing, when you're in the job, when you need to take leave or you're working in the job, how much you get paid. You can't get paid less because you have a disability, and then in every other condition of the job. Who is a person with disability? Disability is a person who has an impairment that impacts a major activity, a major life activity. And this definition has been the definition since the beginning of the ADA, and it has expanded over time. But some of these with PI impacts every single one of these things. There are days when, all of this stuff, we don't feel like we are impacted by our PI. Generally, it's been found under the law, just PI in general, a diagnosis of a primary immune deficiency impacts one or more of these and is officially a disability. So what does an employer have to do when we come in and we say, okay, I have a disability, I'm a qualified employee, you can't discriminate against me, so not only can they not discriminate against you, what does that mean? Well, what they need to do, if you're qualified and you can do the job, is they need to accommodate you and accommodate your disability. Now, that accommodation has to be reasonable. But the law says they have to give you, as an individual with a disability, a reasonable accommodation. A reasonable accommodation is a modification or adjustment to a job practice policy or the work environment that allows you to perform your job without an undue burden on the employer. Now that makes sense. You're an employee, you can do your job, and the employer should, help you do your job. Now we're not demanding that the employer go through something unreasonable, build a whole new wing for you or something like that, but we're expecting some consideration. And these are reasonable accommodations. Probably many of us have asked for and received some of these things. Time off from appointments, modifying a work schedule, working from home. That's the biggest thing. So many of us can work from home now. We don't have to be at an office. Now maybe the boss would like to see his employees in the office once in a while or all the time. But if your job says you don't have to be in an office and your disability says there are certain days you just can't get up and get into an office, you can't commute, you can't get on the bus or the subway or something like that, it's a reasonable accommodation to say you can log onto your computer at home and do your work from home. Extra training, relocation of your work area. Maybe you can't be on the third floor, but maybe they have an office on the first floor. Might be in a different department, but you can still do your job from there. These are the types of things that are reasonable. And if you read them, they are pretty reasonable. What is unreasonable? An undue hardship on the employer. Something that's going to cause financial difficulty for the employer. And that's not just, installing a ramp or something, something like that. That's not a financial difficulty. But when you have a small business, 15, 16 employees, and to accommodate your disability, there is something that would impact that employer significantly. The employer can say, this isn't a reasonable accommodation, and we're not required to do this for you. It's not required to change the type of operation it does. If they run a factory and you are not able to do your job at the factory because of your disability, then you aren't qualified. And if there's something they can't do to that assembly line or something like that, they don't have to change the way they do business. But for the most part, if we go back, I don't know how to go back. If we go back, most of these types of things, these are the kind of things we require, that we would need to be able to keep doing our job and doing it well. And so these are the kinds of things we would expect. What does it prohibit? Discrimination, failure to accommodate, harassment. That's another thing. What is harassment? That's sometimes a judgment call. But I have heard, and I've spoken to many people in the PI community who, when they tell people about their needs, when they tell people about their disability, even if it's just, hey, I need time off a couple days for my infusion because it really affects me and wipes me out, that the employer can't make fun of you, can't tell anybody about it. They can't have the people around you at work, you get a couple extra days off. You're lazy. There can't be any harassment about that. That's a hostile work environment, and that's something that the employer, even if it's your fellow employees that are doing this to you, your employer is responsible for stopping that. The divulging confidential information is also an important thing. The only people that need to know are the ones that should know. So an employer can't spread word of your PI, or you take a day off every month or every 2 weeks, you take a couple of days off for your infusions. The employer can't tell everybody else in your department why you're doing that. That's your information. If you choose to tell, that's up to you. But your employer or your HR department can't spread that around. Even if they get, well, why does he get to take off a couple of days? He gets to take off a couple of days, that's it. That's the basis of the Americans with Disabilities Act. First stop for the American Disabilities Act violations is your HR department. If the HR department doesn't help, the Equal Employment Opportunity Commission is a government agency where we as disabled people can file a complaint. Hopefully we can get some kind of resolution before the EEOC. If it has to go to a hearing in the EEOC, it can do that. After the EEOC, then we have the court system. I do advise, and I know reasonably it's not always the easiest thing to do, but there are lawyers who make their living doing nothing but representing people with disabilities. Sadly, they make a pretty good living. because there is a lot of discrimination against people with disabilities out there. You know, I am not one of those lawyers. It's not what I do on a day-to-day basis. But I do recommend when someone comes to me and they'll tell me, hey, this is what's going on at work, you know, my first advice is, okay, well, talk to HR, see what they can do. Well, you know, I talked to HR, they said they can't do anything. Eventually there's going to be a time, sadly it's going to cost you a little bit, but the benefits may outweigh, you know, the cost in the long run. There are lawyers out there, and they're not even lawyers, there are special advocates out there that, you know, that don't have to take, you know, your case to court. There are advocates out there. You can come to IDF, and IDF can refer you in the right direction when you feel you're being discriminated against. There is help out there. There are nonprofits out there that can help you. So you're not doing this alone. Family Medical Leave Act. So the EEOC protects you in getting your job and keeping your job. The Family Medical Leave Act helps you when something happens while you're on the job. So you have a job, something happens, you get sick, you need protection. Well, what kind of protections do you have? Family Medical Leave Act entitles eligible employees of covered employers, and those are two new different legal definitions, to take unpaid job-protected leave for specific family and medical reasons. You get to keep your health insurance and keep your job. You get to return to your job in the similar or in the same job or a similar job when you come back. Who's eligible? Employer covered by the employees that are responsible or that are covered under the FMLA are employers with 50 plus employees, and 50 plus employees within a 75-mile radius. So they don't all have to be main headquarters 50 people. They can be 50 people spread out over 75 miles. But if this company employs 50 plus people, they're covered under the FMLA. They have to comply. Sorry, I didn't have it up there. Going back, an employer has to comply with the ADA if they have 15 or more. So that one covers many more employers. 50 plus for FMLA. To qualify as individuals, we have to have worked for that employer for a year. And we have had to, in the past year, have had to have 1,250 hours during the past 12 months. We've demonstrated we are actually working there. We are true employees. We didn't just get a job and then try to come for health insurance reasons and then go out on disability or something like that. You know, we've demonstrated that we, as employees, are part of the workforce. Then FMLA is available to us. Why can we step away from our jobs under FMLA? Our own serious health conditions. For patients with PI, that's us. That's what we need to utilize FMLA for. But for the families, you can take time off. You can take this unpaid time off for the care of a spouse, a daughter, a parent with a spouse, a son, or daughter, a parent with a serious health injury or injury. So our families, if our patients' parents need to take some time off, take care of their kids because their kids have the disability, their kids have the PI, that you're able to, under FMLA, qualify to take that time off and have your job protected. And other things such as a newborn baby. And there's also, FMLA also covers active duty military in order to protect their jobs and their families' jobs as well. You can take up to 12 weeks a year. And you don't have to take them up. You don't have to take them all at one time. You have up to 12 weeks under FMLA. You can take them intermittently. So if you have days you need to use FMLA for your infusions. Yeah. If you you have to be out for a certain number of days because of your infusions, or you're going to be out because you have to have surgery, and you're going to be out for 3 weeks, and then another month later, 2 months later, you have another illness. You're going to be out for another week. You would qualify, all this time would qualify under FMLA. You don't have to use it all at once. You can spread it out. You have up to 12 weeks. Yeah? You have to use up your regular leave before you go back? That is up to your employer. So generally, yes. And the employers are going to make you most often going to make you use up your earned time off, your leave from work, and then say, okay, now you'll qualify for FMLA. But that's an employer's, that's their right to do, and so you have to check with your employer and see what their policy is. But most often, I do see that, yeah.
What about coming in late? Using the FMLA intermittently or coming in late?
That I can't speak to off the top of my head. That to me would be an ADA accommodation. I mean, if you can come in, if you have to come in late and then put in time somewhere else, if you can still qualify, do the job and meet the job, I would say that would be a reasonable accommodation under the ADA. But if the hours add up and you're paid, you're paid hourly or something like that, and they count, oh, well, if you were 2 hours late, that's 2 hours. You're 2 hours late, every day, that's 10 hours. That's almost 2 days. Then we would, you could look under the FMLA. That would cover you. Yeah. Okay.
So you get sick.
Mm-hmm.
Okay. And how many, by law, I'm assuming by law, how much time do you have to go before you should submit the paper, because like if you're in the hospital or you're too ill to fill out, this is a lot of paperwork.
It is a lot of paperwork.
Okay. To do that, where will you get in trouble? That we wouldn't, because.
Right, and I get it. Yeah.
Okay, and I'm freaking out because I need to get that paperwork in, but it was taking me a little bit longer.
Yes.
But I was afraid I would lose my job because I didn't get it.
Right, and so what's going to happen usually if you have time off accrued at your job, if you have leave at your job, they're going to count that first. So you have a little leeway, a little cushion. But if you don't, FMLA is retroactive. So you don't have to apply right at the onset of your condition, at the onset of your leave. You can apply later, and I can't speak honestly to the specific number of days you have to apply, but I know you can apply after the fact and have it applied retroactively. This is all unpaid leave. Sorry, that's the bad news. The bad news is this is FMLA is unpaid leave. Now, I mean, FMLA does coordinate with your short-term disability plans if you have things like that through your employer, but FMLA is unpaid leave. The purpose of it is to keep your job secure so that you at least have a job to come back to after your leave, and more importantly, keeps your health benefits. That's for us, that's the key. So if you're on if you're on FMLA leave for 12 weeks, they can't cancel your insurance, and then all of a sudden you can't pay for your infusions. That is the key under this law to protect us. Your employers have to tell you about it. Sometimes they don't. Usually you probably have a break room, and every office has some kind of water cooler or something, and employers plaster it all over the place. But they have to let you know about it. They have to maintain the group health insurance and maintain you on the group health insurance. Same or equivalent job benefits. Yeah.
So, to your point about it being unpaid leave, allowing you to maintain health benefits, is it correct then to assume that since most of us have our health benefits deducted from our pay, that then we have to come up with the money to pay for those health benefits during this leave?
No, they have to keep you on, so they would pay for your health benefits.
They would pay?
I believe they would have to. Pay out of your paycheck? Right. Anybody have experience with that?
Yeah.
Please, right there.
So, typically when you go out on leave of absence, like you leave PTO time, it would take the payment out of that of the regular paycheck. But if you run out of PTO time and you run out of disability and you're still out, they would have to pay you.
So you would still get a pay stub, right? But it would be just that amount?
No, you probably wouldn't get a pay
No?
stub,
Okay.
but it would be something that they would charge.
Go ahead.
I work for an employer with 40 employees.
Mhm.
I have a lot of things.
Yeah. Unfortunately, yes. I mean, I just had an experience with a friend of mine who was out on a leave, tried to get FMLA leave for He was out for a month, and his employer was 8 employees, and he couldn't qualify. His employer fired him. So what he ended up having to do was apply for unemployment. Unfortunately, was able to, he got some guidance from a consultant that helped him, file the right paperwork and get the right stuff in. And so that's how he was able to sort of stay afloat. Depending on the terms of the short-term disability plan, I would say, yeah, definitely, you would apply for that. And that's the purpose, I think, ideally of an employer would be obtaining short-term disability because they're not required to provide this to their employees. It's an added benefit. Yeah.
Does it vary from state to state?
No, this is a federal law. So this is all 50 states.
We're under 40 employees, and it comes out of the state check.
Well, then each individual state can have greater protections. So I don't know. I'm honest. I can't speak to each different state. But this law is a federal law, and this law sets the floor. So states can provide greater protections. Kind of like if you talk about HIPAA for privacy and things like that. The HIPAA sets the floor, and states can provide greater privacy protection. And, it's sort of the same idea.
And this is not part of the Affordable Care Act, right?
No, FMLA came along long before the Affordable Care Act. So based on, we have those 2 laws that provide protections for those of us with disabilities, but there are so many other just general questions about what do we do as people with a PI when it comes to getting a job or keeping a job. After this session, I'm going to go talk and lead a panel discussion with the young adults. I do a lot of work with our Teen Escape program, and I have a lot of teenagers that are hitting 17, 18 years old, and they're thinking about their future. And we talk to the young adults, and the young adults are coming out of college. Well, what about us? What do we do? How does your PI impact your job search? Well, we just see the FMLA requires at least 40 employees. Do you need a job that you anticipate you're going to be taking FMLA leave and you need that protection? You might have to look at jobs with more employees. A big thing is, like I said, most of us get our health benefits from our employer. Okay, so that's great. So now we need to find a job with an employer that is of sufficient size to be able to afford a health plan to offer us that can cover us. And that's important. We don't have a choice. We can't necessarily go off and start our own shop and do our own thing. Now, the Affordable Care Act helped considerably in providing the exchanges and providing ability for individuals to go out and find health insurance and providing small employers the ability to go out and provide health insurance. It really gave us a lot of protections. As we've seen, particularly over the last 2 years, the Affordable Care Act has been under attack. It's been weakened already some, and it is. And we've been promised that it's going to continue to be under attack, and there are people just across the river who are determined to get rid of the Affordable Care Act. If and when that happens, every one of us in here suffers. So that's something we have to be concerned about.
You know why?
Why what?
Understand why they're attacking ADA.
Well, we're not going to really get into the politics of why they're attacking the ADA or the ACA. Sorry. No, it's purely political, and that's why. Yeah.
I'll be on the other side of that fence. I've seen socializing medicine on the other country, and there's no panacea.
All right. Well, we're not going to get into a political discussion. No, it is. We're not going to get into political discussion. The fact is, we all have pre-existing conditions. We live with pre-existing conditions, or our loved ones lived with pre-existing conditions. If there is not protection for people with pre-existing conditions, every one of us in this room either suffers or our loved one suffers. That's just period. Politics aside, that's a fact. So how does the PI impact your job search? We need to think about it, insurance. That's the most important thing for us. How are we going to afford our infusions? How are we going to afford our sub-Q? Should I disclose my PI? You don't have to disclose your PI. No one with a disability is required by law to disclose. let me take that back. I'll say this the other way. You are protected, and an employer cannot require you to disclose your disability.
They put it on the application. I'm going through that process right now. Every single one that I applied for, you're supposed to declare whether you're, have a disability.
You do not have to answer that.
I think I just put no, but I
Yeah.
mean, because I'm in that, if you have a disability that impacts your ability to work, to do this job, right?
Yes, they can ask you if you have a disability that will impact your ability to do the job. No, of course not. No, of course it's not. But yes, an employer can screen if you have a disability that will impact your ability to do the job that you're seeking. And quite honestly, if you're trying to get a job that your disability impacts your ability to do the job, you probably shouldn't be applying for that job. But the thing is people with PI, we can pretty much do any job that we really want to. I mean, there's nothing, generally, I speak in very general terms, but there's nothing about a primary immune deficiency that necessarily keeps us from specific types of employment. So you cannot be required to disclose your disability. You don't have to, they can't ask about it in an interview. They shouldn't ask about it on an application. If you can do the job you're applying for, you have every right to come in there and do the job you're applying for without having to tell anybody about your disability.
But then why is the affordable, not the affordable care, but the other one,
The ADA.
why isn't there then?
Well, because,
Those questions are related to the equal employment opportunity.
yeah.
For demographics, because they always, I'm unemployed right now, I'm looking, it always follows like male, female, Hispanic. It's the same thing, it's not supposed to impact an application, so it's separate.
Yeah, it's,
At least in theory.
in theory. I mean, that's the thing. Well, see, the reason we have the Americans with Disabilities Act is real life gets in the way. And that when you are employed, or if you, I mean, we don't have visible disabilities for the most part. You know, you could not look at me and say that guy has hyper-IgM syndrome. When I explained it, I walked in, I'm a lawyer, I work for a big law firm. And I didn't tell anybody about my disability when I got in there. I'm able to do my infusions at home, so I would just duck out a little early and have do my infusion at home on the days I did my infusion. I would do it on a Friday, so if something, and usually I don't have any problems usually, but if I needed to sleep in a little on Saturday, I'd do it then. And then all of a sudden we had a big case come in where my law firm was representing a couple drug companies. And senior partner comes in and says, Brian, we're going to get you working on this case. And I looked, and one of the companies happened, and we were representing them, but one of the companies happened to be my IVIG products company. And it was not related to IVIG at all. It was on something completely different. As a lawyer, I have to disclose, that I have an interest and I have a possible conflict. And so I said, yeah, well, you know what? There's something up. And I told them. They said, okay. We'll make a note of it. We'll let HR know, and everything was fine. So
You told them about your PI?
Mm-hmm. Yeah.
And that you used that product from that company and you couldn't work on the case?
Yeah, I had to disclose why I couldn't work on the case, but I had to disclose my disability. And that's going to come up for most of us. We're going to get sick, and we're going to be out, and sometimes we're not going to get sick, and we're going to be out of work more than just the normal person, more than the person in the desk next to us. So we're going to have to say, hey, I need an accommodation. I have a disability. It's something that I need. I can do the job and I can do it well, but I need, some help. So that's why we're protected. That's why the law is for, to protect us. But we don't have to disclose, because if we disclose up front, it's possible that we could turn somebody's eyes, their mind against us. And so we are protected. We don't have to do that. Now, the flip side of that is, what if you want to do it? And I work with the teens and I work with the young adults, and a lot of those kids come in and they are amazing. And they volunteer for IDF, and they're out raising money, and they're organizing, and they're writing articles, and they're in the paper, and they're doing all kinds of stuff that is really, really impressive. It looks amazing on a resume. So you put it on a resume and you're sitting in front of an employer and they say, well, what's this and why? Why not? This is something I do. It looks great on a resume because it is great. It's work I do. I'm proud of it. I work hard at it. It's amazing. And it just so happens that I have a personal connection to this because I have a primary immune deficiency. And look, I have a primary immune deficiency, and I did all of this on my resume. So it can be a positive as well. So the trick is, we get to determine that individually, and I think that's the point I'm trying to make, is that it's up to us to just tell an employer, it's up to us whether or not we tell an employer up front, or we wait till we need it, but that's our choice, yeah.
I just want to put a plug too for disclosing because it can be helpful. I work for the federal government and I applied to the Schedule A program, which is for people with disabilities. And for that, they are trying to fill slots for people with disabilities. And it's actually easier to get a job if you have a disability because they can bring you in under a different way than the regular competitive system. So it's not always a bad thing.
No, exactly, and government jobs are different than private sector jobs. In law school, I worked for the Department of Education one summer, and I needed some time off to get out early to do my infusions, and I went to my boss and said, I need some time off to do my infusions, and I started to explain. He's like, I don't care, just do it. So there are employers that are just okay with, I don't have to worry about it as long as you can do the job, you can do the work, then just do it. A lot of times it's also, you can do the job, you get in and you show what you can do. You show the employer that you're qualified and that you can do the job, that this is the job you sought, and then you can do it, and so then they can believe you. They know you can do it, so it makes the reasonable accommodation to a lot of them a little more reasonable. Yeah.
When you talk about the FMLA and the employees for greater,
Yeah.
are there any other entities or employers that are exempt from the ADA or the EEOC?
I cannot tell you off the top of my head. So that is something we would have to look up. I don't want to make anything up, and I'm not an EEOC or an ADA lawyer. Yeah, in the back.
What did you say the program was for applying with disabilities?
Schedule A, it's called, and each agency is supposed to have a Schedule A coordinator that helps with that. But if you want to come up and talk to me afterwards, I'll give you one.
But again, what we do with it is our choice. What do I do after I get the job? If you've disclosed, and they know. If you haven't, and something happens, you get sick, or if you're a parent, your child gets sick, and you need to take advantage of either the ADA or the FMLA, you need to go to your HR department if you're at an employer that has a HR department. You go and you fill out a lot of forms for the most part, but that's where you start. And most HR professionals and most HR people, know what they're doing, have been trained in the ADA and FMLA. They will, that's the first step. Yeah.
So if you have a morbid condition that could become life-threatening rather quickly, and you haven't disclosed, how do you handle that type of situation? You probably, maybe more to the group too, somebody in your organization should be notified, if not your boss, that's something that we've been kind of struggling with the whole community.
Well, I guess the question is, if you have a condition and you disclose your PI or your general condition first. If you haven't, yeah. Do you wait until the fact that it becomes life-threatening? I guess that's the question. Do you want to set up are you talking about setting up a safety plan so somebody knows in case something happens while you're on the job? That could be, that could be part of your disclosure. You don't have to go into too much detail necessarily. If you're disclosing and you say to your boss or to HR, said, this is I have this disability. Sometimes something might happen. This is who to call, or this is how to handle it. I don't think there's no requirement you need to go into details that it could, that there is a life-threatening situation necessarily, but you can. Again, these are sort of non-legal questions. These are sort of finesse questions. Yeah. You got who's your boss, who's your employer. Do you know that? What kind of personal relationship do you have? How long have you been there? What have you proven yourself? These are the questions that we need. You have to sort of evaluate. The whole picture. Because we do need to protect ourselves any way we can. That's most important.
Can I give a little bit of advice and a warning?
Of course.
With FMLA, I've been doing it for several years, no problem, with reading all the instructions very carefully. It's very important to make sure you're asking for specific days or hours. It's very important that you fill that out correctly. I've been doing it fine. All of a sudden, HR started giving me trouble. and they tried to trick me so it would work. And I luckily knew the rules well enough. And I work for the federal government, so I just wanted to warn you.
Right.
Not all agencies are the same.
Right, and some employers,
Read the instructions.
some employers make sure that you cross every T and dot every I, and if you don't cross every T and dot every I, they have the technical right under the law to, not give you your benefits and to let you go. Ultimately, an employer is they're a business, and their job is to make money. And if you look at them, take away the human component of it, their job is to make money. And if they have an employee that they have to pay, or they're covering on insurance, that might cost them extra money. Maybe not having that employee on a purely technical basis benefits them as a company. Most of us are work in places where there's actually people there, real human interaction, and so we need to weigh what our company is like, and what our needs are when we make the ask, and when we make the disclosure, and we do. But we do have to be sure we fill out all the paperwork right, and that's not easy. Yeah.
When should you participate in FMLA or internet?
As soon as you know.
Or which would be better?
Well, if you will apply for FMLA, and my experience with applying for it, because I had to take disability time off as well, is that there was just one application. And that once my FMLA was in, I got the time, and then when I was done, I had to send in the paperwork that said I was done. So I was out for, X weeks, and then that just counts against my 12 weeks.
Okay, so it doesn't really matter.
Right. So for me, it was one application. That's how my HR had it. So the next time I was out, I could fill out paperwork again, but there was not. I didn't have to choose, like check a box intermittently, thinking that I'm going to be out for 12 whole weeks this time.
Because I'm a teacher,
Mm-hmm.
so I know it's way different in a lot of things. All right, but what my lead people told me was that if I put down, let's say, sinusitis, that I was out for sinusitis
Mm-hmm.
for 2 months, then I could, if I went back to work and I had to go back out again, it would have to be within sinusitis. If it was something else, then it would have to be another FMLA.
Yeah.
Like, if you had the immune deficiency.
Right. If you apply, if you apply as primary, as CVID, every time you go out, you're going out for CVID, even though it's a sinus infection here and pneumonia there and something else another time. Look at that. We even have a couple extra minutes. Anybody else have any questions or comments? Yeah.
I just wanted to say, I was really nervous, my last employer, I was really nervous about telling them that I was newly diagnosed, and I didn't know what else to do, so I did go to my manager in Hopkins. And I was relieved because he said, I'd much rather have somebody like you who really cares about your job and is willing to, do whatever it takes to get the job done, than the next guy who doesn't care and, isn't there half the time and all that good stuff. So it was like saying, if you're a good employee, then you really don't, it's okay, like you said.
Yeah.
You can do the job, they're just like, whatever,
Right.
do what you have to, but as long as the job gets done,
Yeah, and after you've proven yourself, it's much easier to request leave than if you haven't proven yourself yet. But you also have to keep in mind that if you go to your manager and say, I have this disability, your manager's then going to go up the chain of command.
you mean he had to go to.
He's going to go. Yeah, eventually that's going to end up at HR, because that's what he's required to then tell his boss. You're telling your employer. They can't go and tell people that don't need to know, but he can go up and he can tell HR that you've disclosed that you have a disability.
What does that do to your, because you always wonder, when the time comes, do they go back and look and say, oh, we've got employees, and oh, look at this one is a problem.
Well, first of all, every time they review their health insurance coverage, they look back and go, oh, that employee is costing us a lot of money. It's there. It's not something we can hide. But if you have a conversation with your manager and your manager is, you know, okay handling it in his division, in his department, his or her department, then that's fine. But just know that the manager then can, if it's, you know, he may be required to then take it to HR. And that's where you get your protections, is once you get into HR and the company officially knows about it. That's when you get your FMLA protections and your ADA protections also. So it's not as though it's a bad thing. It's just something to be aware of.
I think the other time they look at that is what they're doing like opportunity too, who can be the person to go, okay.
But under the law, they're not allowed to do. Under the law, they're not allowed to do that. Now, we know they do. We know they do, but under the law, they're not allowed. And a lot of employers will come up with some sort of other excuse as to why you're being let go. All of a sudden, you can have glowing employment reviews up until, oh, layoffs are coming up, and all of a sudden you have a couple less than positive employment reviews, and then you're let go. Yeah, that's probably not because you all of a sudden became a bad employee. These are things, you know, we don't want to paint all employers as, you know, nefarious actors, but it happens, and it happens more often than it should, that's for sure.
If you have noticed improper disclosure by management, I haven't had it happen for me personally. It was at another job. They did it to another person. It was around the time of insurance, and they were like, well, if this guy really wasn't here, we wouldn't have such high premiums, because, you know, he's always out sick. I think they did it out, like, in one of the insurance meetings.
Mm-hmm.
And can you report that about somebody else, or does that person have to report it?
The ADA also has in it a provision that protects whistleblowers. So if you have, and I'm sorry I didn't bring that up earlier, if you know of an ADA violation by your employer, whether or not it's against you or somebody else, they're also on all that paper that are all over the water cooler and everything. There should be a hotline for your employer that you have the right to report anonymously something about, you know, an ADA violation. And if they find out it's you, you are protected under the law. Now, again, we also have the, you know, I'm a lawyer. I know what the law is, but I'm also a realist, and I know what real life is. And so, yes, you know, you have the right for them not to disclose, and it's a violation if an employer discloses to employees. But what you can do about that practically isn't always something tangible. It's not as though you can get you may not be able to get anybody in trouble. It may not be so damaging that it's worth challenging or suing or anything like that. It's just really a really bad thing for them to do. So yeah, I mean, there is a distinction between what is legally prohibited and what the law is, and what happens in real life. And sometimes, you know, sometimes people do things that we just can't change. Yeah.
When you have, say you're applying for a job and you have, you know, put together your resume and there's, you know, a gap.
Mm-hmm.
Resume, and then, you know, employers a lot of times will ask you, like, why do you have a, you know, year or whatever.
Right. Again, we get out into the same thing. I know what the law is, and I can tell you that they can't, you know, specifically ask you, were you out disabled on all this, or were you sick, or anything like that? It is. It's a matter of finesse. Then we talk about, well, what did you do during that year? How do you want to describe it? Oh, I was sick, and I was surviving about, with my CVID, and it made me very sick, but I got through it, and now I'm here, and I'm out on the other side, and I am stronger, and I am better, and now I'm ready to apply for a job, and this is the same kind of work I did before, and now I'm back. Maybe that's how you present it. You're right, because plenty of people have gaps because they were out sick, and so what happens? You want to ignore it. Oh, well, you can't ask me about that. Well, then there's a huge then there's a huge red flag. We're not going to talk about those. Yeah, exactly. Yeah, exactly. We're not going to talk about that very dark time. It's. We want to just be able to, that's, again, that was the best word, I think, that you used, finesse. It's about finesse. It's about knowing yourself and what your story is and how best to discuss that with confidence. Again, I look at some of these kids who are amazing, and they've done some amazing things, and they come out and they're proud of their PI. because it made them who they are and the things they've done. So it's, they're almost excited to be able to tell people this. Very different than when I got my first job. But, good for them.
Have you always had known about PI?
I have. I was diagnosed when I was about 3 years old, 2.5, 3 years old. So I've lived with this my entire life. So, yeah, it's been part of me through school and, getting my first job and all of that.
I had a friend that used to say I was out caring for a family member. She said, I am a member of my family.
That's a good point, too. Exactly. That's another finesse. Yeah, I was out. I had a sick family member. I was caring for them every day. I woke up with them every day. Threw up in the toilet every day with that family member. I get it, yes. So, yes, and that's another, it's just, that's the finesse that we have to do. You're protected under the law. This is what the law says. But what do we do, common sense-wise? The bottom line is what the law does is it gives us the power and us the ability and us the decision-making, authority over our disability.
I had one quick question.
Yeah.
To segue on what you said, it's actually quite obviously the follow-up question is going to be, oh, really, who? And now we do.
Make up a name of a not a name. Your imaginary.
But then, again,
So what I'm getting at is relying on a job interview.
yeah, exactly. I mean, you're finessing, and you're finessing, and that's, but that's the thing is, hey, I took care of, a family member who, oh, it's me. This is what I was. You don't have the right to ask me, but, it's all about the finesse. All right, our time is up. We have another session to go to, so I appreciate your time.